Hey guys, welcome back. Here is a revision lecture on CA Final Paper 4 Corporate and Allied Laws. We'll start law with a very simple and easy topic, National Company Law Tribunal and Appellate Tribunal, which we used to call it as NCLT and NCLAT. Come, let's get started. First of all, we need to understand that these NCLT and NCLAT has been constituted under the Companies Act 2013. Prior to this, there are Company Law Board which was constituted under Companies Act 1956, and there are other boards, Board for Industrial and Financial Reconstruction and Appellate Authority for Industrial and Financial Reconstruction. By taking over these two, NCLT has been constituted. NCLT is a quasi-judicial body that adjudicates matters pertaining to companies in India. This we have already learned, that NCLT will take up matters that are pertaining to companies in India. If any person agreed by the order of NCLT, he can appeal to NCLAT, which is the appellate authority. Okay. NCLAT is having a chairman and such number of judicial and technical members not exceeding 11 as the central government may deem fit. It is saying the constitution of NCLAT. It is saying that there will be chairman plus members of judicial and judicial and technical nature not exceeding 11 as prescribed by the central government. NCLT and NCLAT has provided a single window for settlement of all disputes relating to companies. This we know that it acts as a single window clearance of all disputes. The provisions of IBC, that is Insolvency and Bankruptcy Code, have already been incorporated in this act. This act means Companies Act 2013. Come, let's see the constitution of these two, NCLT and NCLAT. Section 407 provides the definitions of chairman, judicial members, president and technical members. The section defines the following key members constituting the NCLT and NCLAT. Okay, we'll identify each and every person's definition, qualifications, because of which they will be appointed as members of NCLT and NCLAT. Chairman means the chairman of appellate tribunal. Judicial member means a member of tribunal or an appellate tribunal as such, and includes the president and the chairman as the case may be. Hope you are clear with this. Judicial member is in both NCLT and NCLAT, and it also includes the president or the chairman as the case may be. It means NCLT and NCLAT both, it includes president and chairman plus other judicial members, other members. A member, whether judicial or technical, of a tribunal or an appellate tribunal, and includes the president or the chairman as the case may be. Hope you are clear with these two terms. President means the president of tribunal. Technical member means a member of tribunal or appellate tribunal as such. By going through this definitions, you might be understood that NCLAT constitutes of chairman, judicial member, technical member, whereas NCLT constitutes president, judicial member, technical member. You should clearly identify chairman, president to differentiate between NCLT and NCLAT. Appellate tribunal will have chairman. NCLT, that is ordinary tribunal, will have a president. Appellate tribunal will have chairman, that is NCLAT will have chairman, NCLT will have president. Come, let's move forward. The order of tribunal under section 420. this is a general rule that any order has to be passed only after giving a reasonable opportunity of being heard. Hope you are clear with this. This is a general point which you need to write in every answer wherever a question has been asked on orders. And then amendment of order. The tribunal may at any time within 2 months from the date of order, with a view to rectify any mistake apparent on the record, amend any order passed by it. It is saying that NCLT can review, can amend any order that it has passed within 2 years from the date of order. Hope you are clear. Within 2 years from the date of order, provided that no such amendment shall be made in respect of any order against which an appeal has been preferred under this act. What it is saying, we know that if any person aggrieved by the order of NCLT can appeal before NCLAT, that is the appellate tribunal. Suppose if NCLT want to amend its order, but the same order has already been appealed against in NCLAT, then such kind of orders should not be amended by NCLT. Hope you are clear with this. Second, the copy of order to the parties concerned. This is obvious. The two things that are obvious in orders is it should be passed by giving a reasonable opportunity of being heard, and the second one is the copy of order should be given to both the parties to the appeal. Hope this is clear to you. Appeal from orders of tribunal. How can you prefer an appeal? See, appeal to appellate tribunal. Any person aggrieved by order of tribunal may prefer an appeal to appellate tribunal. That is clear. When order is made by the consent of parties, no appeal shall lie to the appellate tribunal from an order made by the tribunal with the consent of parties. It is saying that whenever an order is passed by the tribunal, such order means tribunal's order is passed only with the consent of both the parties to the appeal. If both the parties have already agreed and the tribunal is also agreed and gave order in such manner, now these two parties cannot prefer an appeal before NCLAT. Hope this is clear. Period for filing of an appeal. By reading these lines, you will be confused. Just look at this diagram. Copy of order received by aggrieved party. We already know that any order has to be sent to both the parties. After receiving, within 45 days, you should prefer an appeal before appellate tribunal. And if there is any delay and if the reason is considerable and if the appellate tribunal feels it is okay, then it will grant you another 45 days as condonation of delay. Hope you are clear with these terms. Condonation is like forgiving of the delay. So, appeal from appellate orders of tribunal is clear to you. Section 421. Copy of order received. We have to prefer an appeal within 45 days to appellate tribunal, and there can be a condonation of delay up to 45 days. Same thing. Pass order after giving a reasonable opportunity of being heard. Copy of order of tribunal and parties to the appeal has to be given to both the parties aggrieved to the appeal. And section 422. Expeditious disposal by tribunal and appellate tribunal. It is saying that any appeal which has been preferred before tribunal or appellate tribunal has to be disposed within 3 months from the date of presentation before the tribunal or before filing an appeal before the appellate tribunal. It is saying, we know that there are NCLT and NCLAT. Whenever a case has been presented before NCLT or whenever an appeal has been preferred before NCLAT, that is tribunal, appellate tribunal, these two parties, whether it is NCLT or NCLAT, has to dispose this particular case within 3 months from the date it is presented before it. Hope this is clear. If there is any delay due to any reasons, then the tribunal or the appellate tribunal has to record in writing the reasons for delay. Hope this is clear to you. See this diagram, you can easily make out. Matter presented before tribunal or appellate tribunal, this has to be disposed within 3 months. But there can be a condonation of delay up to 90 days, wherein the tribunal or the appellate tribunal has to record reasons for delay in writing. Hope this is clear to you. Please consider this point. In general, in our usual language, you can say that 3 months is equal to 90 days. But in law language, 3 months is not equal to 90 days. Please remember this. Whenever law says 3 months, it has to be 3 months. Whenever law says it is 90 days, it has to be 90 days. This point will be tricked in MCQs. Please be careful. An MCQ can be formed like this. What is the maximum period of condonation of delay under section 422? Options may be given wherein you will be finding 3 months and 90 days both in the options. You have to be careful and select 90 days because in law it has been clearly written as 90 days. It has not been written as 3 months. So please be careful. If law says months, you should say months. If law says dates, then you should also say days. Hope you are clear. And appeal to Supreme Court, which is under section 423. An appeal, any person aggrieved by the order of appellate tribunal may prefer an appeal before the Supreme Court within 60 days from the date of receipt of order from appellate tribunal. Hope you are clear. Condonation of delay here also will be granted up to 60 days if the Supreme Court feels it is sufficient, it is okay to give condonation. If the reasons for delay has been sufficient, then it will be giving you condonation of delay. Hope this is clear to you. Then next comes section 424. Procedure before tribunal and appellate tribunal. See, tribunal and appellate tribunal will have its own procedure. It all depends upon the code of civil procedure. It is like natural justice. It will go like, it depends on case to case. There is no fixed procedure where tribunal and appellate tribunal has to follow it strictly. So, the law says, tribunal regulate their own procedure based on natural justice. That's it. There is no fixed procedure at all. It is bound by the procedure laid down under Code of Civil Procedure. Hope you are clear with this. And then powers vested in tribunal and appellate tribunal is as that of the civil court. What are the powers? Come, let's check it out. Summoning and enforcing the attendance of a person and examining him on oath. You can summon any person and ask him or enforce him to come and appear before you, and you have the right to examine him on oath. Requiring the discovery and production of documents. You can ask the person, tribunal can ask the person to present any documents or any evidences on affidavits, receiving evidence on affidavits. Subject to the provisions of sections 223 and 224 of Indian Evidence Act 1872, requisitioning any public record or document or a copy of such record or document from any office. Anything can be asked by NCLT or NCLAT. Issuing commissions for the examination of witness or documents. It can ask for examining witnesses or the documents. Dismissing a representation for default or deciding it ex parte. If there is any default on the side of the parties who have appeared before them for an appeal, then it may take a decision ex parte without considering their things, because they have not even appeared, they are not following the orders of tribunal or appellate tribunal. Setting aside any order of dismissal of any representation for default or any order passed by it ex parte. and any other matter which may be prescribed. Hope you are clear with these points A to H. These are the powers of tribunal and appellate tribunal. And then nature of decree and its execution. Any order made by the tribunal or the appellate tribunal may be enforced by the tribunal in the same manner as if it is a decree made by a court in a suit pending therein. And it shall be lawful for the tribunal or appellate tribunal to send for execution of its orders. It is saying that the order of a tribunal or an appellate tribunal can be enforced as a decree made by a court. It is like it is a final order which has been made by the court and it has to be enforced. It can even send for execution of orders. Okay, within the local limits of whose jurisdiction. In case of a company, it is the registered office of company. In case of any other person, the person concerned voluntarily resides or carries on a business. Hope you are clear. Nature of proceedings. All proceedings before the tribunal or the appellate tribunal shall be deemed to be the judicial proceedings. Okay, any proceedings before tribunal and appellate tribunal shall be the judicial proceedings. Power to punish for contempt. The tribunal and the appellate tribunal shall have same jurisdiction, powers and authority in respect of contempt of themselves as a high court has and may exercise the powers under the provisions of Contempt of Courts Act. If tribunal or appellate tribunal has made any order and if the person hasn't agreed, then it has the power to punish the person. What can be the punishments? See, which shall have the effect subject to the modifications that the reference therein to the High Court shall be construed as including a reference to the tribunal and appellate tribunal, and the reference to Advocate General shall be construed as a reference to the law officers or as the central government may specify in this behalf. So, where contempt this in case there are any default in the person, then the tribunal or the appellate tribunal has the same powers as prescribed under the Contempt of Courts Act, which is equally applicable to the High Court and the Advocate General's law officers of the central government. In the same way, it is applicable to the tribunal and appellate tribunal also. Delegation of powers. The tribunal or appellate tribunal may delegate some or general orders, specific orders, directions subject to such conditions. It will delegate its powers, few of its powers, in specific to some case, or in general it can delegate. It has the power to delegate. Hope you are clear. Protection of action taken in good faith. Suppose if any order has been passed by the tribunal or an appellate tribunal wherein the order has been passed by it under good faith, then there won't be any legal action, legal suit, prosecutions against the tribunal or appellate tribunal, because the tribunal or appellate tribunal has passed its order based on good faith. Hope you are clear with this point. So section 428 is also done. And then comes section 430, civil court not to have jurisdiction. This point you will be seeing in maximum all the acts also, because civil courts will not interfere in the proceedings of tribunal and appellate tribunal. This point will be in almost all the acts. No, you can even see this act. This act is having overriding effect all over the acts. So these are the general points which you can note it down and use whenever they are necessary. And then section 431, see, any vacancy, I mean if there is any vacancy of members, either judicial or technical, in the tribunal or the appellate tribunal, and where an order has been passed by the tribunal or appellate tribunal, then such order shall not be invalidated because of vacancy in the constitution of Nclt and Nclat. That is what is saying Section 431 is saying vacancy in tribunal or appellate tribunal not to invalidate acts or proceedings. Hope you are clear. Section 432 right to legal representation. Any party to any proceedings before the tribunal or appellate tribunal may either appear in person or authorize any one or more of the chartered accountants, company secretaries, cost accountants, legal practitioners, or any person to represent his case before the tribunal or appellate tribunal. It is obvious, mostly CS, CS, CWAs, these people will represent clients before. This is usually seen to our language, general language. We will be seeing this in income tax also. CS will represent its client before the income tax department officers. Likewise, even in Companies Act also, before NCLT and NCLAT, the person aggrieved may appoint one or more of authorized representatives to appear before NCLT and NCLAT. And then Section 433, provisions relating to Limitation Act is equally applicable to this also, tribunal and appellate tribunal proceedings. And transfer of pending proceedings, Section 434. This you can easily understand that before Companies Act 2013, we will be having Companies Act 1956, wherein we have Company Law Board. This section is saying any matters, proceedings or cases pending before Company Law Board shall now be stand transferred to NCLT. Hope you are clear. All matters, proceedings, cases pending before the Company Law Board shall stand transferred to the tribunal, and the tribunal shall dispose such matters, proceedings or cases in accordance with the provisions of this act. Okay, and next suppose if Company Law Board has passed its order and now Companies Act 2013 came into picture and this NCLT and NCLAT has formed. Now, if any person is aggrieved by the order of Company Law Board, can now prefer within 60 days from the date of communication of order an appeal before NCLAT. Sorry, it is not NCLAT. It can prefer an appeal before High Court. Any person aggrieved by any decision or order by the Company Law Board may, before such date, may file an appeal to the High Court within 60 days from the date of communication of decision to him on any question of law arising out of such order, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing, it can allow condonation of delay up to 60 days. Okay. All proceedings under the Companies Act 1956, including proceedings relating to arbitration, compromise, arrangements and reconstruction and winding up of companies pending immediately before such date before any district court or high court shall stand transferred to the tribunal, and the tribunal may proceed to deal such proceedings from the stage they transferred. It is saying that before this NCLT and NCLAT, if there are any proceedings which are pending before the district court or the high court on matters relating to arbitration, compromise arrangements and reconstruction and winding up, shall now be transferred to the NCLT, and NCLT shall continue the case from where it has left. It has left means from where the proceedings have already been done, that has to be ignored, and from that point it has to continue. It is saying from the stage before it is transferred. Suppose High Court have done up to 40% of the proceedings, but now the case has been transferred to the NCLT, the remaining 60% has to be taken care. The first 40% should not be redone. Hope this is clear. Provided that only such proceedings relating to the winding up of companies shall be transferred to the tribunal or at a stage as may be prescribed by the central government. It is saying the central government may transfer only from a particular case, particular stage. Suppose if a case has already been done 90% by the High Court, Now, what is the use of transferring the same case to the NCLT and asking NCLT to perform this 10%? So, the central government will consider the necessary parameters and ask the High Court or the District Court to transfer the case to NCLT. Hope you are clear. Provided further that all proceedings under the Companies Act other than cases relating to winding up that are reserved for orders for allowing or otherwise such proceedings, the proceedings relating to winding up which have not been transferred from the High Court shall be dealt in accordance with the 1956 Companies Act 1956 and rules thereunder. It is saying if the central government feels that a particular case should not be transferred to the NCLT or NCLAT, then such cases has to be dealt in accordance with the old act, that is Companies Act 1956, but not under the new act Companies Act 2013. This can be twisted in the examination. Please be careful. If any proceedings has not been transferred from the High Court or the District Court to NCLT, then such cases has to be dealt under the previous act, that is Companies Act 1956 and the rules thereunder, but not under the new act Companies Act 2013. Hope you are clear with this. The central government may make rules consistent with the provisions of this act to ensure timely transfer of all the matters. Hope you are clear with this chapter. And then there's the few questions which are given in test your knowledge. Check it out. Multiple questions. Any person who is aggrieved by the order of appellate tribunal may approach the Supreme Court on any question of law within 60 days. If in the options it has been given 2 months and 60 days, then 60 days is the correct answer, but not 2 months. Please be careful. Days, months has to be remembered, but not which is equal to, which is our general language. In our general language, we will consider 1 month equal to 30 days. But in law, that is not the matter. If law says 2 months, 2 months. If law says 60 days, then it is 60 days only. Please be remembered. And then, what is the procedure to file an appeal for orders of the tribunal under the Companies Act 2013? We have already seen that a person aggrieved by an order of tribunal may prefer an appeal to appellate tribunal within how many days? Within a period of 45 days from the date of order. Reasonable opportunity has to be given before passing an order, and a condonation of delay of 45 days shall also be granted. Copy of order of appellate tribunal shall be given to both the parties. Hope you are clear with this chapter, NCLT and NCLAT. That's here is an end for study material. We'll get back if there are any questions in our past papers. We'll be back with another video. Thanks for watching. If you find this useful, please like, share and subscribe to our channel. Bye bye.